Good evening, everyone. I think we still have over 100 people with us. This is the Energy Facility Site Evaluation Council's set of hearings tonight on the Horse Heaven Wind Farm project. We just completed about 7-8 minutes ago the public information meeting. We're on a break right now until 8:30, just a few minutes away. My name is Adam Torum. I'm the Administrative Law Judge presiding over these hearings tonight. We're about to start the Land Use Consistency hearing at 8:30 p.m. I anticipate that should go at least an hour. We're going to have an opportunity to hear a roll call of the EFSEC Council to make sure we have a quorum. We're going to hear from the applicant. We're going to hear from Benton County, and we may have some public comment, land use comments as well. This is a specific, very focused topic. It's not about general concerns. That was the previous meeting. This meeting is going to focus on land use, zoning, and those kinds of issues. So if you already commented in a general way, there's no need to comment again in this matter. You can submit your land use comments electronically, by mail, through the EFSEC portal. Staff will describe that process again, how to comment on land use and the rules as we begin the hearing in just a couple minutes. So bear with us. We're running about an hour past the budgeted time tonight, but we'll stay with this, and hopefully about an hour for the land use consistency hearing, and maybe a little bit longer depending on comments. And please realize that the applicant has withdrawn their request for expedited processing. So this discussion of land use tonight is just the beginning of a focus on whether or not this complies and is consistent with local land use ordinances and zoning rules and regulations. We'll be on the record in just a few minutes.
Judge Torum, are you ready to begin the land use consistency hearing?
I was about to click my unmute button. You beat me to it, Chair Drew.
Trying to be timely. It's a long evening, and I appreciate all those who are participating with this. As required by RCW 8050-090 sub 2 and WAC 463-26050 and WAC 463, that's Washington Administrative Code 463-26060. I will call to order this land use consistency hearing, and during this hearing the public will be given an opportunity to provide testimony regarding the proposed project's consistency and compliance with land use plans and zoning ordinances. And with that, I will ask the clerk to call the roll of the council.
Department of Commerce.
Kate Kelly, present.
Department of Ecology.
Rob Dangle, present.
Department of Fish and Wildlife.
Mike Livingston, present.
Department of Natural Resources. Utilities and Transportation Commission.
Stacy Brewster, present.
For the Horse Heaven Project, Derek Sanderson.
Yeah, Derek Sanderson, present.
Ed Brost.
Present.
Chair, I believe we have a quorum for the council and for the Horse Heaven Council.
Thank you. Judge Torum.
Thank you, Chair Drew. Again, my name is Adam Torum. I'm an administrative law judge, and this is the land use consistency hearing for the Washington Energy Facility Site Evaluation Council. This is regarding docket number EF-210011. This is an application filed by Scout Clean Energy back on February 8th of 2021. The Siting Council has appointed me to facilitate the proceedings in this matter, and I'm presiding over tonight's land use hearing. As the chair said, this is being held pursuant to Revised Code of Washington 8050-090 and Title 463 of the Washington Administrative Code, or the WAC. This public hearing is being held online due to some ongoing health restrictions we've all become too familiar with. It's necessary due to the COVID-19 coronavirus pandemic. The council would normally be local in Benton County for these types of public hearings, and the council does hope to be in your community later in this process whenever the health and well-being circumstances allow. Notice of this particular land use hearing was published in your local newspapers, in the Tri-City Herald and in the Corvallis Gazette-Times. If you as an individual want to ensure you're notified and informed about all future EFSEC proceedings in this Horse Heaven Wind Farm project proceeding, make sure you sign up on the EFSEC website, and you'll be getting email notices, and you'll be notified of every proceeding that's going on, and perhaps even every document that's filed so you can review it. There are public documents on the Energy Siting Council website. That's www.efsec.wa.gov. We've already called the roll and established there's a quorum. Tonight, there's not going to be a vote or a decision on land use consistency. I want that to be clear. Both sides here, the applicant and Benton County, have filed legal briefs, and the council will be taking those under consideration after they hear the presentations tonight, and they'll also be reviewing any public comments. We're going to take public testimony in this particular hearing. It's not just a comment. So the testimony, if it's given by any witnesses, again, not by the attorneys that might be making their points and presentations, but I'll swear in each individual witness to give their testimony, so it's sworn. It can be taken tonight orally in the hearing. You can submit also written comments and electronic comments. The focus of these comments should be with regard to whether at the time of the application, and again that's as of the laws in effect on February 8th, 2021, whether this proposed Horse Heaven Wind Farm project is and was consistent with local and regional land use plans and zoning ordinances. The applicant, Scout Clean Energy, submitted their application to construct and operate a 1,150 megawatt wind turbine and solar electrical generation facility in Benton County, Washington. Again, that's 1,150 megawatts as the nameplate generation level. This council, the Energy Facility Site Evaluation Council, or EFSEC, the rules allow for the applicant to provide what's called a certificate from the local authorities attesting to the fact that their proposal is consistent and in compliance with county or regional land use plans and zoning ordinances. That has not been provided, but if it is, whether tonight or at some later date, that certificate will be regarded as prima facie proof and evidence of land use consistency. So that means they'll have carried their burden if they can present such a certificate, meaning that the county is also in agreement and saying that this project is consistent with your local codes, ordinances, and land use plans. Now, if Scout Clean Energy does not or cannot provide such a land use consistency certificate from the county, and they do not demonstrate compliance with local land use plans and zoning ordinances, then this council will have to request testimony from the county, sworn testimony, not just the summary presentation by the county prosecutor's office tonight, and only after hearing sworn testimony, subject to cross-examination as well, received throughout the process and consideration of comments, only then will the council take and make a determination about zoning and land use consistency. Tonight, in addition to those presentations, we have Assistant Attorney General Bill Sherman. He's known as Counsel for the Environment. He has a separate interest in land use issues as well as Counsel for the Environment. And for the record tonight, Mr. Sherman, if you're still with us, I know you were at the previous public information meeting. If you're here, I'd like you to introduce yourself for this audience and this record and briefly explain your duties under Revised Code of Washington, Chapter 8050, for those that are still listening and present tonight. Mr. Sherman, are you out there?
Thank you, Judge. Yes, I'm here. Again, my name is Bill Sherman. I am an Assistant Attorney General with the Washington State Attorney General's Office. I'm the Division Chief at the Environmental Protection Division of our office. Under state law, the Attorney General is authorized to appoint a counsel for the environment for projects like this. Under state law, my role is to represent the public and its interest in protecting the quality of the environment in EFSEC proceedings. I will put that legal citation to the law that authorizes this appointment and my email address in the chat thread. Thank you very much, Judge.
Mr. Sherman, we'll look for that information in the chat thread. Part of your audio cut out, at least on my end, and I know we're bearing with some technical difficulties tonight.
I'm sorry, Judge. Is there a portion that that would be helpful for me to repeat?
Anything you said that I didn't hear came after you said you'd put something in the chat thread. If you want to repeat from there.
I think all I said was that's it.
Okay.
I don't think I had anything to say after that. Thank you for checking.
Thank you. Those two words didn't get to me, and they were not the most important words, but indicative of when you were done. Thank you, Mr. Sherman.
Thank you.
All right. Again, this land use hearing is a separate process from the earlier public comment and information hearing. So again, as I said, we're focusing now on only one narrow aspect of the project, the land use consistency. And we're going to begin with some presentations, first from the applicant and then from the county, from Benton County. I believe we have on the line legal counsel for Scout Clean Energy. I'm anticipating hearing from Tim McMahon, a partner with Stoll Reeves LLP in Portland, Oregon. Mr. McMahon, are you on the line?
Yes, I am, Judge Torm. Thank you.
All right, and once we hear from Mr. McMahon, I believe we're going to hear from the county attorney, Chief Deputy Prosecutor in the Civil Division, Ryan Brown. Mr. Brown, are you on the line?
Yes, I'm here. Can you hear me?
I can. I understand, gentlemen, that you're each going to take about 15 minutes to make your presentation. That's what we've budgeted. Mr. McMahon, is that going to be sufficient?
That should. Thank you, Your Honor.
And Mr. Brown, is that going to work for you as well?
Yes, I may not take that long since the Scout withdrew its request for expedited processing, but that'll be the maximum amount I would take.
All right, Mr. Brown, I might hold you to that. You're right in that. We got notice yesterday that the expedited processing was being withdrawn and that a full environmental review would be conducted on this project, an environmental impact statement. And I'm sure that Mr. McMahon will address that as well. Does the council or the chair have any questions or comments before I turn it over to the applicant and the county? Hearing none, I'm going to remind our representatives of the parties to speak slowly and deliberately. We do have a court reporter, even though you can't see her. She's been through enough already tonight with the public comment hearing. And have mercy, Mr. McMahon, I turn the floor over to you. We'll see if you go 15 minutes and let me know if you need more or less. Go ahead, sir.
Thank you, Your Honor. And I do have a tendency to talk fast, so I will take that direction seriously. Judge Torm, Chair Drew, members of the council, thank you for this opportunity to present this evening. We did file a hearing memorandum in the early morning hours of last Friday. Our circulation wasn't perfect. I apologize to Ryan about the way that it was circulated. But in any event, we did each receive each other's presentations, and I don't anticipate any objection from either of us with respect to that matter. As Judge Torm indicated, Scout has withdrawn its request for expedited processing, which makes this hearing a lot less exciting than it would otherwise have been. Scout does not at this time intend to submit testimony concerning specific land use code provisions. We will not repeat the content in our land use memorandum, and we concur with the county's attorney that an adjudicative hearing will be held later in this process to address these and other requirements and criteria, specifically the CUP criteria found in the Benton County Code. That is not something we intend to address tonight, although we have written a summary response to those criteria in the second half or so of our adjudicative hearing memorandum. An adjudicative hearing is outside the scope of what is needed at this time and would be quite redundant with a later process. that we, I think, agree on, that will be informed by SEPA and be informed by a full evaluation of the ASC at that time. As I understand it, the county's argument essentially, just even setting aside the consistency, or excuse me, the expedited processing issue, is that the county disagrees with the council's inquiry as explained in the Columbia Solar order, which I'll talk about in a minute. The county takes issue with the expedited processing, which of course is now moot. And there is a contention that what we consider to be a somewhat debatable lot setback standard, which is not a land use zoning allowance question, may or may not have been accurately addressed in the application. We appreciate the comment that the county submitted, and we will certainly look to ensuring that our narrative and the approach that we're taking to development conforms with that standard. So the council's approach to land use consistency is not, as I indicated, it is not a land use adjudication, but it is a limited and very discrete inquiry at this point in time. As Judge Torm indicated, under the EFSEC statute 80.50.090 sub 2, the question at this time is whether or not the proposed site is consistent and in compliance with city, county, regional land use plans, or, I emphasize, or zoning ordinances. And prior to the issuance of the council's recommendation to the governor, a public hearing conducted as an adjudicated proceeding will be held. So that is not, again, being held tonight. At the time, or excuse me, the statute, the EFSEC rules that frame the purpose of the land use hearing indicate that the purpose is to determine whether at the time of the application, the proposed facility was consistent and in compliance with land use plans and zoning. Now, at the time of the application, the only thing that can be ascertained is whether a use is allowable, not whether it complies with all the specific land use criteria. That's what the adjudication is for at a later time. We have, as I indicated, evaluated in the second half of the memorandum the county's specific conditional use permit criteria, but we don't intend to go into that at all really this evening, because that is a subject of later adjudication. As I indicated before, if we were still pursuing expedited permitting, this would be a rather different conversation than I think we're having this evening. I'm now just going to quote from what really is the most recent controlling authority on what this all means. It was in from the Columbia Solar order, paragraph number 35, where the order explains the test for consistency and compliance. And states, under the test for land use consistency previously established by the council considers whether the pertinent land use provisions prohibit, and that's in quotes, the sites expressly or by operation clearly, convincingly, and unequivocally. If a site can be permitted either outright or conditionally, it is consistent and in compliance with the land use provisions. This site can be permitted conditionally, consistent with the county's code. We did append to our land use memorandum discussion, it was in an email really, from the county planning director that certainly indicated that the use is allowable conditionally under the conditional use criteria in the county code. So I really don't think that there's much to dispute about that at this point in time. As we understand it, the county's primary contention here is with the abbreviated consistency and compliance standard that's applicable to expedited permitting. The county argues that there is no statutory or regulatory support for the standard, and that Scout, by seeking expedited processing, which is now moot, is somehow dispensing with an adjudicative hearing. So in terms of the statutory support, RCW 80.50 concerning expedited permitting expressly references the public hearing provision in RCW 80.50.090. So the legislature clearly intended that for the inquiry of consistency under section 090, the decision will be based upon an adjudicative public hearing that's referenced in that statute. So the council does have the authority to conduct, multiple hearings really, but certainly an adjudication dealing with land use compliance at a later time. Deference to EFSEC's interpretation. EFSEC's interpretation of the statute in WAC 463-26 is entitled to substantial deference. The Washington Supreme Court has been clear on giving great deference to an agency's interpretation of its own promulgated regulations. And that would be, there's ample law controlling that, which I can certainly provide citations to. An adjudicative hearing will be held, as I've indicated, and as Judge Torm indicated. The council may hold also, quote, additional public hearings under the statute as deemed necessary, and an adjudicative hearing will be held. This is how the process is actually intended to unfold. So the adjudicative hearing will allow an evidence-based level of unbiased objectivity informed by a robust SEPA review, none of which is possible for this project in Benton County. Now, there have been several comments indicating that the project should be permitted locally. Well, we've heard the county commissioners indicate that they oppose the project, and we've heard opposing testimony from the planning director. So I think it's clear enough why we're here seeking a fair and objective review by EFSEC versus the county. Finally, concerning preemption, ultimately the legislature directed that EFSEC and not the local jurisdiction would be the ultimate decision maker to the siting, and that land use consistency, while relevant in the council's analysis, may also be preempted under RCW 80.50.110, WAC 463-28-010 and -020. For the court reporter, I'm hopeful that that was slow enough. And then finally, there is this issue about setbacks. Again, we appreciate the comment from the county. We believe that we have indicated compliance and how we will comply with the setback. The setback, however, is not a zoning land use zoning ordinance within the meaning of the statute dealing with land use consistency. So I do want to comment briefly about Mr. Wentz and Ms. Cook's statements at the beginning of the hearing this evening concerning the Growth Management Act preservation of agricultural land use as some indication that this use is not allowable. The Growth Management Act, it does not control the local development per se in this county. Actually does have a code that allows wind generation facilities and the solar facility and the storage facility under the conditional use criteria. The county plan does have language in it concerning natural resource areas, tourism, rural character, and the like. Again, the issue at this point in time is not whether or not this project is consistent with any specific comprehensive plan provisions, but whether or not comprehensive plan provisions somehow disallow the use as an allowable use versus a prohibited use. There's a vague and general indication that the project does not comply with the zoning ordinance. That's not something we understand, nor is it reflected in the narrative that we've attached to our memorandum from the conversations that we had with the planning department. And then just general concerns about the critical areas, regulations and ordinance that we will certainly address as we move forward. So at this point in time, that is a summary of Scout's position on land use consistency. We believe that within the meaning of the statute and the Columbia Solar Order, that the project is in fact consistent with pertinent local land use provisions. They do not prohibit the sites expressly or by operation, convincingly or unequivocally, and therefore the project is, for this purpose of this proceeding at this point in time, to be considered consistent with land use. Thank you.
Mr. McMahon, I appreciate the being concise. That was 11 minutes, which is perfect. Mr. Brown, you're up. Go ahead, sir.
Good evening. Ryan Brown, Deputy Prosecuting Attorney on behalf of Benton County. Given the applicant's withdrawal of its request for expedited processing and the late hour that's in front of us, I will rely primarily on the written materials I submitted to the council and will keep my comments brief tonight. As I understand this land use portion of the hearing, the determination now is not for the purposes of determining if expedited processing will be granted. Rather, it is to identify the applicable local land use laws and the application status under the laws as of today's date or the date of their application, to make clear that the project won't be judged based on new local land use provisions that may be adopted by the county at a later date. The intent of my comments, therefore, are to describe the local zoning for this land and the proposed use by the applicant, just so we are all clear as to if and how the project would be evaluated by the county if the applicant had not chosen to submit its application to council, but rather had submitted it through the normal process to our planning department. And then in doing so, allow you to determine at the appropriate point if the project is consistent with and in compliance with the county zoning. There's no disagreement by anyone that the zoning for this project is the county's Growth Management Act agricultural zone, and the project before you constitutes a use identified in that zoning code as a use that would only be allowed in that zone upon receipt of a conditional use permit. That permit, if Scout had applied to Benton County, might or might not have been issued. That would have been decided after an evidentiary hearing before the county's hearing examiner. The burden of proof would have been on Scout at that hearing, and so I assume it will be at the adjudicatory hearing that's going to be held by EFSEC, and they would have had to show, demonstrate, present evidence to allow the hearing examiner, or in this case EFSEC, to make 5 conclusions in order for Scout to get that conditional use permit. They would have to demonstrate that the use is compatible with the surrounding uses in the area. Second, they would have to demonstrate and present evidence that the use would avoid materially endangering the health, safety, and welfare of the surrounding community. 3, they would have to present evidence to allow a finding that the use will not cause traffic in the area to conflict with current traffic patterns. 4th, they would have to present evidence that the use or the project does not adversely affect public services in the area. And lastly, 5th, they have to demonstrate that the project would not hinder or discourage development in the area, which frankly is probably one of the biggest problems they're going to have, to demonstrate that they would be entitled to a conditional use permit and would be able to undergo this project under the Benton County Code. Mr. McMahon stated that it's his understanding, and it's mine too, I just want to confirm that the compliance or satisfaction of those conditions will be the subject of the council's adjudicatory hearing that will be held later, and that's fine with the county. But it's our position in that case, there's no reason to issue an order now that the project is consistent with the zoning, because we don't know that until all the evidence is in, and we don't think that the council should issue that order now based on what we believe is an erroneous legal test set forth in the TUSO opinion that was quoted by Mr. McMahon, and frankly is not supported by any legal authority and is contrary to the language of the statute. It's not to be a finding of whether this might be allowed under the local zoning, it's whether it is in compliance. And frankly, none of us will know that until all the evidence is received at the adjudicatory hearing. It's for those reasons the county was opposed to the request for expedited processing, because that hearing, either before the county hearing examiner or before this council, has not been held in order to allow people to offer evidence in opposition and present evidence on those 5 criteria for a conditional use. Whether the project is allowed under the local zoning would be entirely dependent on the evidence received in the evidentiary hearing, which the council, as opposed to the county's hearing examiner, will now hold at some point in the future. After receiving that evidence, the council and the governor will have the information needed to determine whether sufficient conditions could be imposed so as to address the problems created by this project, or whether the project simply needs to be denied. The county believes at this point, particularly based on the type of testimony and evidence you heard from the public earlier this evening, that you will receive evidence at the adjudicatory hearing that would require the denial of the conditional use under the Benton County Code criteria. At best, the county believes it's premature for the council to determine at this point if the project actually is in compliance with the Benton County Code as far as whether the proposed use would be allowed or not. Based on what you've heard from the public tonight, we think it probably does not meet the criteria. Just briefly on the setbacks, as outlined in the county's brief, we would like to point out that even if the use were an outright allowed use under the county code, the project as proposed is not consistent with the specific county zoning standards regarding setback requirements. The applicant proposes that its solar array infrastructure be constructed to span parcel boundaries, which clearly violates the Benton County's code section requiring all structures associated with solar power generator facilities be set back from all parcel, side, and rear boundaries. And finally, it's important to note that if approved, this project would become the permanent use of approximately 7,000 acres within the county's Growth Management Act agricultural zoning district. All land within that district has been designated as prime agricultural land of long-term commercial significance. This was done as required by the Growth Management Act and its mandate to local governments to take necessary steps to maintain and enhance the local agricultural industry, to conserve productive agricultural lands, and to discourage incompatible uses. The county is very concerned that a proposal that displaces nearly 7,000 acres, or over 1% of the county's prime ag land, is directly at odds with the intent of the Growth Management Act and the county's land use plan and ordinances that implement the Act's goals and mandates. For all these reasons, the county looks forward to the council's evidentiary hearing that will afford the county and other interested parties the opportunity to develop the record as far as the project's potential long-term impacts on the ever so important agricultural industry of Benton County. And it will allow the people of Benton County an opportunity to provide evidence of the various impacts that they will suffer from the project if it is approved, whether those be aesthetic impacts or health impacts from light, flicker, and noise. No one here has a crystal ball. Maybe no credible evidence will be submitted to you to reflect these adverse impacts of the project, but the county ventures to guess that you will receive credible evidence regarding these and potentially other significant concerns of such magnitude that you can't address them through conditions of approval, and that the council will need to deny the project. But whichever the case may be, we're glad that it has been settled that an evidentiary hearing will be held to give the people the opportunity to present evidence of their concerns and for the council to receive all the evidence necessary in order to make the appropriate findings and recommendation to the governor. In closing, I'd just like to note that for the people of Benton County, this is not some minor project, as you can tell from the turnout tonight. The applicant proposes to put over 200 Space Needle magnitude structures on our horizon that will produce light flicker, noise, and that will kill wildlife. In addition to taking thousands of acres of land designated as prime ag land out of potential service. This is a very big decision before you, as you well know, and we look forward to the evidentiary hearing to give you the best opportunity to make the appropriate recommendation to the governor. Thank you.
Mr. Brown, thank you very much. Council members, it's now 9:00 p.m. Do you have any questions for Mr. McMahon or Mr. Brown? I ask that because I understand from staff that there are no other public commenters signed up for tonight. Does the council or the chair have any questions for Mr. McMahon or Mr. Brown? Chair Drew, anything further tonight? And I just want to confirm there are no public commenters requested to sign up. Those were all in the earlier hearing. Nobody's asked to comment for land use. Ms. Bumpus, maybe you can confirm that on the record?
Yes, I believe that's correct, Judge Torum. And hearing no questions from council members, Judge Torum, I think that the record is complete for this hearing for this evening.
I want to thank all those that were courteous tonight and listened and muted their phones. This is difficult, obviously, for us, and it's just as difficult for you to hear and understand the nature of everything going on over the phone and over Skype. I believe the council's switching to Microsoft Teams in the future. That should be a little bit easier, we hope. And like I said, as soon as the coronavirus restrictions allow for travel to the local community, I think you can count on this EFSEC council being there in Benton County to see you and hear you. I will continue to rule with an iron fist from the bench to demand decorum and to demand that everybody treat everybody you agree or disagree with dignity and respect. You can expect that from me. And we'll hope that you are able to do that in person when we're there in the county.